Hi everyone, my name is Gulnur Bikuhanbiatova, and this afternoon I'm going to talk about the Frontier Airlines case where, for discussion purposes, only email cost millions of dollars for the parties. So imagine your team sends, for discussion purposes, only email and then jumps on a call with a key client or a key counterparty. Everyone is under pressure, no one follows up in writing, and then a month later you realize that that call has actually amended the contract that you already have and moved millions of dollar risk into your balance sheet. That's effectively what happened to Frontier Airlines in a case that is coming out of COVID. So just to give a high-level overview of that case, basically Frontier Airlines was a party to multiple aircraft lease contracts with the lessor. The airline was about to default, and then in the early days of COVID, in April 2020, the airline sent a rent deferral request to the lessor, and that was done in an email that stated to be for discussion purposes only, and that was followed by a telephone call that happened between the airline, the lessee, and the lessor. And that telephone call was never memorialized in writing. And the complication is that different parties took away different things from that telephone call. So basically, the airline thought there had been a waiver granted, and the lessor thought that they were going to think about it and consider different options. And so a month later, there was a $4.7 million unpaid rent, and the lessor sent a termination notice to the lessee. And there was a litigation, and in litigation, the ultimate issue at stake was whether or not there was a waiver granted. Was it in writing, and did it need to be in writing? And if you ask what the contract actually said in that respect, that would be a really good question, especially for a lawyer like me who drafts contracts. And in that case, the contract actually did include a classic provision saying that the rights of the parties shall not be capable of being waived or varied otherwise than by a waiver or variation in writing. And I think for most people, for most commercial lawyers, that means great, nothing counts unless it's a document that's in writing and that has been signed by the parties. But the court found this is not actually the case. The court found that there was a waiver granted, and in other words, rent deferral could be done not in writing because the words in writing in the contract applied only to variations and did not apply to the waivers. Which I think is a very interesting, very unusual interpretation of the law. Certainly not what people had expected in the market, but in any case, that was the decision of the court. It has not been appealed in the higher courts because the parties decided to settle the case. So I think this is something that we should be mindful of going forward. And so now, if we move forward and think about how all of this translates for tech businesses that are scaling right now, I think it's fair to say that the founders and general counsel, in most cases, focus on key aspects, key economics of the contract, like the pricing, valuations, milestones, results. I think it's fair to say that people wouldn't spend a lot of time negotiating boilerplate provisions, so standard provisions that people for many years thought that they already had been normalized, provisions like the governing law contract, remedies, variations, and waivers. But the reality is that, and as is demonstrated by the Frontier case, this is where the trouble actually lies. So knowing your documents and paying attention to detail and having a second look at your documents actually can be very powerful in terms of avoiding situations that are unintended from a commercial perspective and certainly from a legal perspective. That's number one, we should say, pay attention to detail and know your documents. And number two, I think in the fast-moving tech world, businesses, tech companies, they negotiate and they give waivers over Slack, over Zoom, often under time pressure. People send, for discussion purposes, only emails, and they agree about things, and they say that let's follow up with the paper later on at some point in the future. People also operate under the assumption that they are protected under the no waiver unless in writing clause, and so they make big decisions, big changes or announcements over phone or over email. However, the Frontier Airlines decision actually demonstrates that that confidence could be misplaced. That case teaches that what tech businesses should be mindful of in terms of their informal communications, in terms of their behavior. And I think that case is a powerful reason as to why businesses should be staying in touch with the with lawyers, with the legal people, so that to avoid a situation when your for discussion purposes only email inadvertently becomes a part of the contract. That's all. I think that's all that I wanted to cover in terms of this case. I hope this has been helpful and responsive based on what you actually care about. Thank you.